Good afternoon, everyone. My name is Justin Williams. Welcome to the October 21st, 2025, 1 p.m. docket for the Board of Municipal and Zoning Appeals. My name is Justin Williams. I'm the interim executive director of the BMZA. The board members here this afternoon are David Marcosi, Victor Clark, Leland Shelton, who's the chairperson, Liz Cornish, and Kate Howard. We asked everyone in the audience, please turn off your cell phones. If you need to speak privately with another person, please do that in the lobby or hallway. This hearing is being recorded by the court reporter. So for that reason, please take your conversations outside. When it's your turn to talk for your case, when it's heard, please introduce yourself, spell your name for the court reporter, and take an oath before giving testimony. If you've not already, I'm sure everyone has. If you have not already, please sign in on the sign-in sheet. If you intend to speak on any topic, thank you for that. The board will probably vote in your appeal today, but that vote is not final. By law, we, the BMZA staff, will prepare a written document called a resolution, which requires drafting and review. This process takes several weeks. We will send it to you by email, and if you're the appellant, you'll be able to access it through a SELA. We ask that you do not build or construct anything without a permit in the city of Baltimore. I will now pass the reins to the chair, Leland Shelton, if you're ready to proceed.
Yes. We'll begin with the motion for reconsideration.
So it's a BMZ appeal number 25-0017.
Do you swear or affirm that the answers that you give and the statements that you make will be the truth, whole truth, and
Yeah. Ms. Cole, are you for the Community Law Center on behalf of the Sedonia Community Association? Would you like to begin?
Good afternoon. My name is Denise Coe, and I'm with Community Law Center. And I am here for the community of Sedonia Community Association, which was a party to the original hearing. And they were in opposition to the requests for the variances that were granted. And the written resolution was issued on July 7th. And we had submitted a motion for reconsideration, and we were given this hearing opportunity. And I just wanted to really just bring it to the main point, which really is that the variance legal standards really were not met as to the lot area variance specifically. And if I could point you to the board resolution that was issued, and if we look at page 3, where the discussion on the variances is really starts on paragraph 2. There is a reference to the setback variances and the shape of the lot, which is a nexus justifying the setback variance, but no reference is ever made to the lot area variance. And the 12% lot area variance was of great concern to the community. And no nexus was ever given in the written resolution. And the reason for that is because the application really did not contain sufficient legal basis for a lot area variance. And so because the applicant had never really justified that, the board also did not include a justification for that in its resolution. And as the board is well aware, any variance is the burden of the applicant seeking that variance to be able to show that, you know, all of the conditions that they are required to show under the zoning code. And there really was only ever reference to the unusual shape. There was some reference to wanting to build to aesthetic, you know, like symmetrical, even buildings and things like that. And there were obviously some economic considerations, but none of those are legal justification for being granted the variance on the lot area. And I will just quote here for the record, 5308A requires the board to find that because of either the conditions peculiar to the property or exceptional circumstances related to the specific structure or land involved, a practical difficulty as distinguished from a mere inconvenience would result if the strict letter of the applicable requirement were carried out. But the board did not hold applicant to the standard. The analysis that the board was supposed to find is the nexus for the variance that was actually sought, which in this case that we're discussing is lot area. But there's nothing unusual about the characteristic of the property where they're trying to exceed the minimum lot area. This is R5 zoned, and they were asking to build 40 multifamily dwelling units instead of staying to the allowed 32 or 35. The lot is slightly triangular shaped, which did justify the setback variances, but that's not what we're taking issue with. We're taking issue with the lot area variance. And like the shape of the lot should not have anything to do with the fact that they're trying to squeeze extra dwelling units onto this particular lot that is only, I believe, 87,725 square feet. And, you know, as you're aware, the zoning code in 5308B2 says that you must also find that the purpose of the variance is not exclusively based on a desire to increase the value or income potential of the property, so it
Ms.
can't
Cole, my
solely
first
be
question to
economic.
you is, it seems like you disagree with the decision that was reached by this board. And it seems that that your contentions are of the nature that we did not have proper legal justification to reach the conclusion on the lot area variance. Why you're not, you're not, saying that we reached the decision in error or based upon the evidence or there was some mistake, fraud, irregularity. Just going back to our rules for reconsideration, it seems to me that this might be more of a issue that's ripe for appeal to the circuit court rather than needs to be litigated under our standard for the rules of reconsideration.
Well, it is not a disagreement as to your finding of fact. It is a disagreement that the nexus was completely missing as to the lot area variance. And if you look in the resolution and during the hearing as well, there was a lot of talk about pros and cons and also just variances in general. But in terms of providing what the justification was for the lot area, that was not provided either in the written resolution or, in the board's reasoning during the hearing. And so that is an error that we're hoping that you will reconsider as to the lot area.
Okay.
I have a question. Could you talk about the conversation y'all had after the hearing about the funding?
Yeah,
Is that still an issue?
and I did premise that by saying that shouldn't even be relevant because funding is a separate, it's not a 5308 factor to be considered. But what had come out in the hearing without being explicitly stated is that there was some funding that was secured that would enable this project to move forward, which is all great and fine, but there seemed to be no particular reason that they had to, besides economic reasons, that they had to request 40 dwelling units rather than staying within the allowable 35 units. For this particular grant, Mr. Al had said something that we didn't quite understand, but there was apparently a different grant that he had applied for previously that might have required 40, but the current grant, they applied for 40, but not because they were required to have 40 under that grant specifically, is what I understood from our communications.
What is it your understanding that the city's recent addition of exceptional circumstances to its various standards, what is it your understanding that what exceptional circumstances can be?
Yeah, that's a great question. I think it still ties it to the property specifically. So it's not, obviously economic considerations because that's specifically excluded by law. But obviously I believe there are some examples given, but that there are exceptional circumstances that are related to the specific structure or land that's involved. And so I know there are always pros and cons and, development in general can be wonderful for the city, but in terms of what should be expected by the written letter of the law, the variance standards are what they are, and it is the applicant who's seeking that variance to be able to show that they meet these requirements. And again, the yard setbacks made a lot of sense. There was, justification for that in the written materials, the applications, and during the hearing. But for the lot area, there's just silence on that in the resolution and no adequate justification.
Okay, thank you. Do you have anything else?
No, that's it.
Mr. Barry?
Good afternoon, Al Barry for the developer. Let me first give some context to the board, which you may remember we went over at the hearing. This is a project that was originally approved, I believe, in 2020 and received 2 extensions by the board. The 2020 hearing was an extensive hearing. There was information given to the board, presented to the board that justified the variance at that time, and there was a similar memo presented to the board at the last hearing. We're here obviously in opposition to the reconsideration, that we don't think this issue needs to be relitigated before you. We think that the developer has had a 6 or 7 year history of working with the Hamilton Hills Neighborhood Association. We would continue to do that. If you remember, there was a fair amount of testimony given, and it's even brought up in the request for reconsideration, that there will be environmental issues relating to the presence of groundwater. We have our geotechnical expert here that can answer questions
Was that
about it, but we don't
discussed
think that's relevant.
at the hearing, original, the groundwater, was that an issue?
No, it wasn't an
Oh,
issue.
so it's not an issue here?
Yeah,
It's not an
That's
issue.
what I thought. But I want to say for the record that we continue to, and we will meet with the association, have that explained, that there's really no connection between the groundwater and what is happening with the city's stormwater management plan. We did attempt, and we had some discussions toward an MOU that would have prevented this even discussion. But the MOU in the developer's mind was overly onerous and adversarial. But that's not to say that we would not meet with the community and explain the technical aspects of the stormwater management and the groundwater. That's just for the record, so they hear that. We believe that there was sufficient justification given to the board. We don't write the resolution, we don't review the resolution. How it was portrayed might be something that you can decide to correct if you need to. I don't think you need to. I think you had sufficient justification at the time. The environmental issues we talked about, and the idea of a conversation that we had in good faith outside the hearing is really shouldn't be a consideration for the board today. So I think you approved in 2020, you gave 2 extensions. We actually, due to some confusion over when we could even apply for a 3rd extension, we missed it by 30 days. And so that required, in the then executive director's opinion, we required a new hearing rather than just another extension. That's a practical consideration. Also, from the original approval, the Board of Estimates did approve I think $1 million essentially grant to the development for affordable housing. And that was based on the previous zoning board approval. And that was all discussed at the last hearing as well. So we asked the board not to grant the reconsideration and restart the process over again.
Will I be allowed to directly respond to some of that?
Yes, you'll have the last say, but I want to make sure Mr. Barry finishes first.
No,
Do
is
you
there
have
any
anything
other-
else? Anybody have any questions for Mr. Barry?
I do. The proposal that you handed the board, the estimate from the Board of Estimates, so this was or was not tied to there being 40 units?
It was tied to 40 units.
It was tied.
That's what my understanding is. I wasn't involved with the Board of Estimates approval.
Okay, so can you explain the miscommunication that y'all had after the hearing then? Because
I think it was a private conversation. Frankly, it shouldn't be relevant to this discussion. There was I think the gist of the conversation was that under a previous time frame, there was some discussion about getting a state assistance grant for this that did not come forward.
Yeah.
And that led to this Board of Estimates action.
Okay.
It's not relevant, I think, one way or the other to discussion today.
Well, it's a little relevant because you testified multiple times during the hearing that it was tied to the funding.
The current Board of Estimates approval. Is that what you're talking about?
I'm not sure. You threw around a lot of different funding opportunities, and you said they were all tied to there being 40 units.
Well, I think the board is certainly should be aware that these types of projects for, I'll call them affordable housing, sometimes require some kind of financing that is necessary to provide a gap to make it affordable. And so the developers over the years has looked at various aspects of trying to get that funding. This is just, the Board of Estimates is the last item that we have obtained.
Okay, anything else, Mr. Barry?
No, that's all.
Okay, let's go, make a.
Yeah, I just wanted to correct, groundwater was an issue at the original hearing, despite what Mr. Alberry remembers. It was directly testified by multiple people as to the, and it was actually in the record that the plans that the developer had drawn up specifically cited high groundwater on that lot. And so, one of the points of our motion for reconsideration actually is the consideration for high groundwater and the consideration for the safety and welfare of the community really should have been a factor rather than being dismissed as something that planning could take care of during the site review process. So that's one thing I wanted to correct. And also, I did want to respond to the prior approval that Mr. Berry keeps leaning on. That was expired and it's not pertinent to the factors that they have to meet for this application in terms of the standards for a variance. And lastly, when Mr. Berry seems to remember the funding from the Board of Estimates is tied to 40 units, that's a whole different thing if he applied with plans showing 40 units versus 40 units being required and 35 units being insufficient. And I didn't hear him actually saying that. And I don't believe he's able to because I don't believe it's a prerequisite for the funding that he received.
Okay, any additional questions from the board?
Well, I think the challenge for me is we'll start with groundwater because I think that one's a little more straightforward. We can't predict the future. That's like something outside, like that's an outcome, right? And that outcome around groundwater, the same stormwater management plan and the same geotechnical studies would have to be done whether it was 20 units or 40 units. So I think in terms of stormwater concerns, while I understand that that is a concern that the community raised, I think we can't make our decision based on that concern because that is a concern that does not currently exist, right? And there are steps and processes and it's outside of our purview. It's in the purview of DPW. So I think that is the process at which the stormwater concerns, I think, can be addressed. One, the geotechnical report will come back defining what some of the challenges are. The developer will then be responsible for designing a stormwater management plan that accounts for those challenges because nothing can get built unless it has an approved proper stormwater management plan. So I think that's one thing I just wanted to put on the record, that that is not a concern I have in terms of considering, of evaluating this reconsideration or the challenges with the project or why it might be something that we can't approve. I wouldn't use that as something, whether or not we can and can't approve a project. So I just want to make sure that we sort of remove that. I think in going back over the record, I think the challenge is, was the evidence presented to the board significant to understand the minimum lot area variance, and it's addressed. I mean, I think it's in the record that we did discuss it.
Yeah.
So it was raised.
Yeah, and I'm reading the transcript, and as the chair directly refers that the shape of the property results in a practical difficulty in complying with the bulk and yard regulations, that which we should assume includes the lot area variance. So it was considered. If you disagree with the conclusion reached by the board, the proper form for you would be in the circuit court on appeal. It wouldn't be under Rule G of the BMZA's rules. Any other thoughts? So, because I believe that
Could
the
I-
motion for reconsider,
Could I
no.
ask you for?
No, no. Because after hearing testimony from both the applicant and the appellee, I'm going to vote to deny the motion for reconsideration. The reasons brought up in the motion are, were discussed during the hearing. And so for that reason, I believe that there was no adequate showing in the motion of fraud, mistake, irregularity, inadvertence, or surprise, typographical error, or a showing of good cause as to the unavailability of evidence, the existence of which, could not be discovered before at the hearing. And so for that reason, I'm a no.
I'm also no. After reviewing the resolution, I'm looking under the discussion. It says the board finds that the requested variances, plural, satisfied the necessary criteria for approval. So what that says to me is in the resolution, both variances were considered, a decision was made, and that is why we probably can't, we can't hear that in this venue.
I'm also a no.
And I agree with the rest of the board, and I am also a no.
So I think that is everybody who was present for that hearing. So that is a no for the motion for reconsideration. Thank you, guys.
So, yeah, I think our minutes will reflect that Ms. Howard is abstaining.
Yes. Before we get into our docket for today, I want to make sure that that people are aware that we have have some postponements today. Justin, could you read out which cases were postponed?
Yeah, thank you for that. Put them in the script. If anyone's here for 1813 North Charles Street, case 25-0025, that case has been postponed. The case 912 Washington Boulevard, that's case number 25-0060, has also been postponed. Another case postponed, 1312 North Mount Street, that's case number 25-0070, has been postponed. Another case been postponed, 7201 Park Heights Avenue. It's case number 25-0106 has been postponed. Two more cases to be postponed. 25-0143, this is 5444 Bel Air Road, has been postponed. And then finally, 707 East 34th Street has been postponed. It's case number 25-0152.
Okay, wow. Now starting with BMZ Appeal 2551 6600 Laurelton Avenue, Julie Barth for the applicant. The application is to install a 6-foot tall fence on a property requiring variances to yard regulations. First, we will hear from planning and staff.
Yes, sir. I guess if you're standing in from Ms. Barth.
I'm the homeowner.
Okay. I guess you can sit at the sit at the table and then planning.
There's nothing planning.
Nothing planned on this one. Sir, please stand and be sworn.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Can you state and then spell your full name?
Windsor Calvin Ford II,
Can you spell your last name?
Pediford.
Please, sir, tell us about your project.
I was approved.
You turn your microphone on too. Perfect.
Hello? I was approved to install a 6-foot privacy fence. It's been halted because I have to get a permit from you guys. I don't really know what else you need.
Sure. So, in the R3 zoning district where your yard is located, and because your property technically is a corner
Yes.
lot,
Yes.
you are required to have at minimum a corner side yard of 20 feet.
Yes.
Due to where you are, You're allowed to have a 4-foot fence by right. Anything higher than a 4-foot fence requires that you have maintain the bulk and yard regulations. So, because the 6-foot fence will leave you with no corner side yard, you have to ask us for a variance from the zoning code. In order for us to issue you a variance from the zoning code, first you have to show some unique or peculiar or exceptional circumstances about your property that require you to be waived from having to comply with the zoning code like everybody else does.
Okay.
So can you tell me first about any unique or exceptional circumstances involving your property?
My house sits between like a strip mall where there's a lot of activity coming through. Also on the corner, there's also a bus stop where there's a lot of activity of people coming in. I have, we just installed a shed where I keep a lot of expensive property. I'm a professional musician, so I keep instruments and stuff in there. I have grandchildren that live with me. I like for them to be able to just.
Yeah. And so currently the property is improved with a 4-foot chain link fence.
Right.
And so you would like to maintain the existing footprint, but go 2 feet higher
Yes, sir.
with a privacy fence?
Yes, sir.
Okay. Describe, how close is the bus stop to your home?
It's right on the corner.
Right on the corner?
I don't know how many feet, but it's on the corner.
Which Fleetwood or Laurelton?
Northern Parkway.
So Northern Parkway. So it's not directly adjacent to your home?
It's not directly in my house, but my house is here, and on Fleetwood, there's the strip mall where there's a lot of activity there.
Would you describe it as, how close is the strip mall to your home?
They're both about a block away.
Okay.
In either direction.
Okay.
And just confirming, the new fence would replace the current,
The new fence will replace the current fence, yes.
in the exact same footprint, right?
I'm
In the
sorry.
exact same footprint?
Yes.
Seems like there's a bus stop, Northern Parkway. Okay. And how does that bus stop affect your property? Could you give us more testimony about how that bus stop affects your property?
Just the traffic of people coming through there. The traffic of people coming from the strip mall as well. I'm concerned about the safety of my grandchildren when they're out there in the backyard as well. And just, it's just nice to be able to sit in my backyard and not have someone be able to look into my yard while I'm back there, kind of relaxing, trying to be private.
Yeah, if I may, maybe the board would help to explain on that a little bit more. So is it, the 4-foot fence is not tall enough for people to be blocked from seeing into your
Exactly,
yard? So is
yes.
it because there's a slope or the height of the nearby street is such that people can see into your yard?
Exactly.
Can you describe it?
You have the burden, so you have to convince us that your property is so unique that the rules that all your neighbors have to comply by, you shouldn't be. So if you get this 6-foot fence and your neighbor at the adjacent corner sees you, then you have to say, listen, my property was so special, the board had to give it to me. Or else your neighbor might be down here asking us these same questions. And variances are supposed to be rare, sir.
So there's a 4-foot fence there. There's a chain link fence. Anyone can walk in, they can see into the yard. Like I said, my grandchildren live with me, and I would like to be able to have them go outside and be feel safe, at least feel private, without, people walking by and being able to just look into our yard and decide. We've already had some property stolen from us because of that.
Okay,
You know what I mean? I just,
yeah. Well, could you said, well, you answered that. Can you just describe more about the slope on your property? Is there a slope?
no, it's a flat
Flat
property.
surface.
Mhm.
Okay.
Flat property. We had a few trees on the property which we had removed. The neighborhood itself is feels like a pretty safe neighborhood. Everyone in the neighborhood, I'm about to be 70 years old, so we're all kind of like in the same range. So it's a quiet, peaceful kind of community, but we do have a lot of activity, like I said, coming from the bus stop, because there's a housing complex on the corner where that bus stop is. There's a strip mall there. Every morning, I'm noticing that there are young men kind of hanging out there. I'm not sure what they're doing. I'm not going to say what they're doing, but they're there every morning at a particular time. And I'm just concerned about the safety of my grandchildren. I'm concerned about, my property, not being violated, and it's already been violated twice. Someone came into my yard and took a piece of property, took something from me. So I'm just trying to make my property a little bit more private.
Okay.
If you would you agree that your proximity to Northern Parkway, sounds like you said it before, but to clarify for the board, that you have more people than usual in an R3 district walking
Yes, sir.
by your home, and
Yes.
more people potentially peering into your rear yard?
Yes, the proximity of where my house is located to the corner of Northern Parkway where the bus stop is, and the proximity of my house to the strip mall that's there.
And there's a multifamily building in this mostly single-family residential area,
There is a it's called a Wellington.
which has increased, which causes, what are the effects of having that multifamily building in your mostly single-family neighborhood?
Yes.
What are the effects?
Just the activity, just the activity of people.
Increased
coming-
foot traffic?
Yes, the foot traffic.
Okay. Any other questions?
Excuse me, I'm.
No, you're not. No, you're
I'm
not.
ignorant
You're
about-
good, yeah.
No,
The
you're-
other thing, the board might also benefit, that your neighbors, I'm assuming, you posted the property, the neighbors haven't objected to your proposal.
No, sir. No,
Yeah.
sir.
Sir, I have one question for you, and I think I knew the answer, but just a little more clarification. Have you experienced foot traffic from the bus stop to go down Laurelton and folks turn down Fleetwood to access the strip center that's next to your?
Yes.
Because I'm
Also, they go past my house down toward Pinewood and Westfield. There is a field there, like a football field or baseball field. So yes, there's a lot of activity, and also there's a school across the street from the housing complex where at night cars are like doing donuts and all kind of crazy stuff in there.
okay.
And they do also have, they do have activities there. They have like, I don't know what they are, but I'm guessing like some sort of picnic events.
Okay.
musical
Any other
events.
questions?
They have a bunch of stuff there.
Does,
It's helpful. It's helpful.
And
have
when
we,
those events occur, they're parking all through the neighborhood.
okay, okay. Anything else you'd like to add?
No,
Okay.
I guess not.
Is anybody, okay, thank you. Have we found any unique characteristics about this
Well,
property?
yeah, let me speak to that one a little bit, because I just looking at some of the maps and understanding where applicant's property is located on the specific corner, I can see that there could be a heavy amount of foot traffic that occurs from the bus stop through this community, specifically because of the arrangement of the strip center. Versus probably the assumed path might be along Eastern or Northern Parkway to get into this shopping center, which kind of makes sense. It aligns with what the applicant's saying about the heavy amount of foot traffic, and maybe some of, I don't say it, but maybe some of the reasons why people are hanging out on their corner. So I can find that as being unique to this specific situation.
And R3 is typically a low-density, sort of single-family.
Sandwich between
Yeah.
two heavier dense.
Exactly.
Yes.
A major arterial shopping considered a multifamily complex, increased foot traffic throughout the neighborhood. I think those are sort of the peculiar.
Yeah, there's a clear curb cut into the shopping center off of Fleetwood.
Yes.
So I think that's the sort of thing of like, that's where traffic is directed, is on Fleetwood. To me, that's the most unique part of, peculiar part
Yeah.
of the property.
Yeah. So I think due to these peculiarities, I think the 20-foot corner side yard requirement sort of provides a practical difficulty for you being able to use and enjoy your property. Just increased foot traffic makes the currently 4-foot chain link fence inadequate.
Yes, sir.
And so I could see how the 6-foot fence would be able to provide you with the requisite privacy that you would expect to have in your home. And so I believe that this practical difficulty is completely caused by the code. It's no fault of your own. There's no action or inaction of you as the homeowner. And it's not based exclusively on a desire to increase the value or income potential of your home. You just want to enjoy it.
Yes, sir.
I think the variance will not be injurious or to the use and enjoyment of other property in your neighborhood, as evidenced by nobody is here today in opposition to your application after you posted it in your front yard, I assume.
Yes, sir. Yes, sir.
And so I think the variance is in harmony with the city code. There's no relevant urban renewal plan. It's also in line with the city's comprehensive master plan, and this is not in a CHAP district. And finally, I do not think that allowing you to have this variance will be detrimental to or endanger the public health or safety. So for all of these reasons, I'm a yes for your application.
Under the circumstances and the complete understanding of the code, I could also vote yes.
And I'm also a yes for the same reasons.
Also, yes.
Thank you.
Also, yes.
I'm sorry. I'm so sorry. Thank you, sir. Appreciate you.
What's next? Do I
Something
or something?
Do not make any change. Do not do anything until you receive a resolution in writing from the office. Once you receive that resolution in writing, you can then go forward with building your fence. Thank you, sir.
Thank you.
Now I'm calling case number 25. Well, first, Councilwoman, which matter are you here for today?
On Greenmount Avenue.
Okay, so we're gonna, out of respect for the councilperson's time. Okay, we're gonna call case number 25-109, 3226 Greenmount Avenue. Candidates DeShields Pinkett is the applicant. The proposed project is to use the project for live entertainment, a banquet hall, lounge, and after-hours establishment, requiring conditional uses for all of those uses. First, we'll hear from planning and staff.
Good afternoon, Justin Walker for DOP, here for case 25-109, 3226 Greenmount Avenue. The request is for a few conditional uses to include an after-hours establishment, banquet hall, lounge, and live entertainment. In the C1 commercial district, after-hours establishment, banquet halls, and lounges are neither a permitted nor a conditional use, so they are not approvable. Live entertainment is conditional by board, but only if it is accessory to a restaurant, tavern, or art studio, which is not the case. So due to these, and planning is also aware of a significant community opposition to the approval of the appeal. So due to these uses not being conditional in the C1 zoning district, planning recommends disapproval of the appeal.
I see that there is opposition today for this application, so if you are planning to speak in opposition to this case today, I want to make sure you please stand and be sworn, and also the applicants, please stand and be sworn.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth? I do. And if I can just confirm, you're Miss DeShields?
Yes.
Okay, and you, sir, your name?
Tyrone Diggs.
What was the first name?
Tyrone.
Okay.
And one more.
Are you gonna be speaking? Yeah, let's, well, now that you did speak. No, seriously, what was your name? Okay.
Start with Council Burch, would I get a chance to speak?
Yes, thank you very much, Mr. Chair and Board. I think this is my first time for the new board, I guess. And I just want to say thank you for your time and your service to our city. I am rising in opposition because again, for the same reasons that planning staff has given. You saw my letter, which basically articulated the same, that the uses are just not allowed. And frankly, I feel bad for the applicant because I don't think that they were given the right information from whoever they were working with, whether it was the owner of the property or whatever. So I feel bad about that, but these are uses that are just not allowed.
Yes.
And Ms. Candace did write to me, and I'm glad she did. And I encourage them to have a conversation with their neighbors, which I don't believe happened. And there has been actually some operating illegally in the spot. So I think that I'd be happy to find them a spot where they can work with us or find a business that makes sense on Greenmount, because we always love to have businesses on Greenmount, and I'm very happy that they chose us. Unfortunately, the uses are just not allowed. And these are uses that the community has been very clear would not be acceptable, no matter who the applicant is anyway, on that part of Greenmount Avenue. So asking for your disapproval, but also want to work with the applicants on maybe finding an alternate if there's a way that they still want to be on Greenmount.
Thank you.
Thank
so,
you.
So normally we will allow the applicant to speak and then opposition, then you have the final say. But in this case, we simply cannot grant you the request of relief. The uses that you guys are asking for or requesting are not allowed in the C1 zoning district, which this property is in the C1 zoning district. And so these aren't allowed there. And so for that reason, I think we have to vote no on your application simply because we cannot do anything else. So I do, you should reach out to council person, she's here today, and see what are your alternatives for the property. And so for all of those reasons, I'm a no for the application.
Also a no.
And I'm also a no.
I mean, also, which you understand, you're prohibited by the code, not by our vote particularly, but we have to follow law.
And then I'm abstaining.
Thank you, yes. So now I'm calling appeal 2579, 2033 Eastern Avenue, Chase Hofberger for the applicant. This project is to use the property as a parking lot, principal use requiring conditional use approval. First, we will hear from planning and staff.
So 2033 Eastern Avenue contains approximately 0.8 acres. It is, the application is for a conditional use for a parking lot as a principal use. The site does contain an existing structure, which is a former Burger King drive-through, which is currently a vacant building. Since the drive-through is operating, the property has been rezoned to C1, so drive-throughs are no longer permitted. The concerns planning has here are with the use standards of parking lot per section 14.331 of the zoning code. Item 4 states that no building other than those for shelters of attendants may be erected in a parking lot. The allowable structures may not exceed 10 feet in height or 200 square feet in area. Given the definition of erect, which I'll read off, which is to construct, reconstruct, or move a structure on a lot, or to excavate, fill, drain, or conduct physical operations of any kind in preparation for or while undertaking the construction, reconstruction, or moving of a structure on a lot. So the board will have to determine if the existing vacant structure constitutes the erection of a building on the site. Planning has no objection to the appeal should that not be considered the erection of a structure.
Mr. Hoffberger, what are we gonna do about this vacant building notice?
Sworn, why don't the applicant?
I'm sorry, but yeah, first, please stand and be sworn.
Do you swear or affirm under penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do.
What are we gonna do about this vacant building notice?
Thank you. Thanks for having me too. There are two provisions in the code that are sort of relevant to the issue that you're bringing up here. One would be 5310. The other would be 5410. 5410 says neither the zoning administrator nor the executive director of the Board of Municipal and Zoning Appeals may process any application for conditional use or sign if the subject property has any outstanding notices of violation, fines, or fees that are either unresolved or unpaid. This will obviously be relevant to the old Burger King. To this, we would say that the processing has already occurred. We have been issued fees to pay. We paid those fees. We have been issued signs. We posted those signs. We've been scheduled for a hearing. We are here. So we would say that the executive director, at the time of the first time we appeared here, did process the appeal, the application. Perhaps an error, but we are here. And we're here again. To the second, which is 5310, neither the zoning administrator nor the executive director of the Board of Municipal and Zoning Appeals may approve any application for a variance or a conditional use if the subject property has any outstanding notices of violation, fines, or fees that are either unresolved or unpaid. A close reading of the code says, I'll point to it saying, neither the zoning administrator nor the executive director of the Board of Municipal and Zoning Appeals. The approval occurs, or is the action of the approval is performed by the zoning board, not the executive director. And so this perhaps is a provision of the code that might not meet the original intent, but this is the language of the code. And so Mr. Williams here, in his capacity as interim executive director, does not have a role in the approval necessarily. The approval lies with the board. So we respectfully ask that you hear this case, and if so moved, approve it.
Okay. Let's assume this is properly before us, and it wasn't a mistake that it's before us today.
Yes.
How do you meet the standards under the code for a parking lot, considering that there are existing structures within the property that exceed sort of the 200 square feet, maximum square feet of structures on the property that are supposed to only be for attendants?
Yes, so the code says that you cannot erect any, which is an action, which says, as Mr. Walker pointed out, to construct, reconstruct, or move. The buildings are present, fenced off, and secured. They will not be constructed, reconstructed, or moved. They are there. And to the extent I think it's a matter of interpretation what construction means and what reconstruction means. Some might say that that would involve the expansion of a building or the demolition and then reconstruction of a building. Some may say it involves an interior tenant fit out, right? And that's up for interpretation and discussion. And our clients are prepared to sort of act in accordance with wherever that interpretation falls. One thing that, this is sort of getting ahead of what we're talking about, but the lease agreement with Metropolis Parking, which is the company that would provide the parking oversight for this lot, they would manage their rentals of each space on a very short-term basis, say 3 months at a time. So because our clients are actively looking for a proper tenant for these two buildings, they would have plenty of lead time. And if it was such that no work could be done on these buildings while there is an active parking lot, there would be plenty of time to plan for that, to end the leases for each parking spot, to end the lease with the master leaseholder, which would be Metropolis Parking, and to move forward with the property owner basically abandoning this use as a parking lot.
Okay.
Wait, what do you mean abandon the use as a parking lot? So they wouldn't continue that use once they get tenants for the buildings?
If they get tenants for the buildings and it is deemed by the board and/or the permitting office or the zoning administrator, it is determined that any type of work on those buildings constitutes construction or reconstruction, then that would be worth it for them to abandon their use of a parking lot as they're performing the work for the next tenant. As this is an appeal for conditional use, which can exist in perpetuity, but we are not concealing at all the fact that this is a planned interim use while we handle this sort of problem that exists with the drive-through, and that's fine. That happens sometimes.
Yeah.
And this is a good situation for
And
this.
since these buildings in your wording weren't directed, they can just be screened.
They're there,
shut
they're
off,
fenced off.
unused.
Right.
Until
And-
you get a good lease.
And when a lease is in hand and
Yeah.
permits are secured and work is ready to begin,
Parking lot
then
will
the
end.
parking lot goes away. If that's something that is necessary, I'm not going to make that determination.
It is necessary. I mean, that's the goal.
That's what you're saying. Well, yeah, I mean, that's,
So I think the challenge here is that if I'm a developer and I'm here because I've had difficulty finding a tenant, and so now I need a tenant to be a parking lot operator, what is to say that as a developer, I'm just going to walk away from the site because I've got other things that are going to have more potential, and I'm just going to let that be a parking lot in perpetuity. So it doesn't, I understand you can come here and say, I'm representing the developer and this is their intent, but because I know that, and because of past testimony, that this developer has had difficulty finding tenants for those two buildings, and that is why they are asking for this variance for it to be a parking lot. Or
For the
conditional use, my apologies. So to me, like, I do not want to be in a position to grant a conditional use that would de-incentivize future development, regardless of the intent of the developer. That's just the mechanics of it financially. And so that's my challenge here, is I do not think that the conditional use is in the best interest of that property or the neighborhood. It is in the interest of the developer.
Well, I would contend that it is in the best interest of the community, which has written a letter of support for the use. I would also say that the effort to find a long-term sustainable use is complicated and has not been going on for very long. It wasn't until recently that they determined or realized that they were not able to use the property as a drive-through. You know, somebody buys a property, they live out of town, they live in Sykesville in Florida, and they don't know that Transform Baltimore has prohibited this particular use of a drive-through in this particular zone, and they realize they have a problem and they're trying to find a solution. They're trying to work out with the neighborhood, and there are two ways that this can go. They can actively market the buildings, which they're doing, and they have a letter of intent, and that's not worth anything right now because it's not, they don't have a lease, but it's evidence that they're working in earnest, right? Or as plenty of people in the neighborhood, in the broader community, in City Hall, they can work to fully develop this C1 lot with multifamily housing or retail or mixed use or whatever have you. And that's a large undertaking. It doesn't happen quickly. And certainly financially, that would be more beneficial than a parking lot. So what we're trying to do right now is give the property a little bit of space, clean it up, a little bit of use, clean it up, give the community what they've specifically asked for in the interim, and get us, and sort of buy a little time while making the property a little bit more aesthetically pleasing and useful for the community.
Have you all gamed out what happens if the parking goes away, and what just happens with the community support then? If the community's saying we want it to be a parking lot, and you're saying the developer really doesn't want it to be a parking lot long-term, they want things like housing and businesses that create more pressure on area parking. Are you going to be able to maintain that level of community support?
Well, as the letter of support says, the community, the Fells Prospect community, is very aware that this is sort of a short-term interim plan, and they expect and are assured that the developer plans to continue those conversations in the future. I think that one of the supporting factors to our clients' willingness and commitment to working with the community is that this idea was born out of conversations with the community.
I have a couple questions. So one of the things that we try to focus on, the board and the entire city for that matter, is to minimize the amount of vacant and boarded up properties. So one question is, what is the interim plan for these two buildings? I'm assuming you're going to say that they're going to stay there, they're going to be locked, they're going to be boarded up, they are going to be controlled, they're going to be secured from anybody to enter, vandalize, et cetera. That, to me, is a concern because we're kind of contradicting our purpose. We are allowing the property owner to acquire an income for temporary use of a parking lot. However, we also have two buildings that are going to stay there, be vacant, and knowing that the property owner is receiving some type of income is going to say, hey, it's okay, because during this interim time, when I really need to be focusing on selling this property for redevelopment, if that's the intentions, I'm going to have these two buildings that are just going to sit there, right?
And back
that,
to the issue,
me, is a concern.
Yeah, and back to the issue of the vacant building notice. In order to, remedy the vacant building notice, you're going to either have to demolish the building or get the building up to code.
Correct.
Wouldn't that be erecting a structure on the parking lot?
Well, right, we would need to abandon the use. We'd get.
But we can't issue a conditional use if you have a vacant building. You're not, it says unfit for human habitation or other authorized use. The property itself.
You're saying you cannot approve this appeal. Is that what
Yes,
you're saying?
yes. We may be precluded by law from issuing a conditional use when there's an outstanding vacant building notice that says the building is unfit for human habitation or other authorized use, and that VBN has not been remedied.
Right, well, I would return to what I said at the beginning, which is that the zoning board is not prohibited from approving this conditional use appeal.
Under section 5-406B2, the board cannot approve a conditional use unless it finds that the use would not be precluded by any other law.
Well, I think the question before the board, does this law preclude the board from issuing? Is this a law that, precludes the use? And I guess that's the pertinent question, is the processing one. Because kind of getting to what Mr. Marcosi mentioned on the overall intent of the regime of.
The building code is part of the city law, right?
Yes.
So any structure or part of a structure found to be unsafe or unfit for human habitation or authorized use must be rehabilitated or, as permitted by the building official, demolished.
Well, that goes to the question of the VBN. So the argument, I think there's separate issues here. So the VBN is in place and that's there. There's an argument, I think the applicant is making, is that there's a principal use in the parking lot space only. You could draw,
Right, and he's saying
box,
that's applies to structures.
Separate principal use is here.
Separated.
Structure's gonna stand there. Structure's unfit for human habitation, but that doesn't impact the parking lot activity.
There not be access to it.
The board alternatively could find, kind of what Mr. Marcosi was getting at, is that, well, in fact, a board mistake appears to have happened to processes with the open VBN on this parcel, and therefore you should not approve it.
Yeah, the VBM applies to the entire parcel. land and improvements.
That's an interesting, I think this
I
is
mean, yeah, I
interesting.
mean,
This
it
is the
is-
first time it's
it
come
is-
up. I mean, I think this is
yeah.
probably a first impression issue.
Yeah.
Because generally, the building.
And we're
building
talking
is
about
in the
principal
term.
and
The vacant
secondary
building
uses.
Notice is a vacant building.
Yeah, the principal use would be for the majority of the square footage of the property, it seems, in this, you know. Can we separate the structure from the rest of the property, land? This is fun
I don't think we want to set that precedent.
at all, yeah.
Well, that's probably not something I'd be interested in doing anyways, but.
I'm sorry, what?
No, to the question that
Yeah.
the chair was asking is, could we separate the buildings? That's completely a real estate
Yeah, and
approach
here's
that's probably not of interest.
And here's
Understood.
something that I think might solve this, but that we really haven't discussed yet. Are we still processing this application?
That's another question.
And would approving this, you know, if we've already made the mistake, will we be increasing the magnitude of the mistake that we've already made by granting you a conditional use as opposed to just saying this shouldn't have been before us anyway? We can always correct one of our mistakes.
I agree. I mean, or I acknowledge that that's the case.
I think we solved the issue then. For the reasons just stated, I do not believe that this application is probably before the board. I think we're still processing it. It should not have been submitted to us. It was submitted prematurely because there is a vacant building notice on the property. And for that reason, I am going to deny this application.
Okay, understood. And so the whole processing was
It was premature.
performed in error.
Yes, premature.
And the board is taking action to correct that error.
Yeah, corrected our mistake, yes.
So just so that I understand, they are welcome to reapply and come back once the vacant building notice has been
Yes.
rectified.
Yeah, but
I
we
would presume
can't-
that there's no need to actually reapply because we haven't been denied and we have paid our fees. If we can fix this situation,
Or we could just say refund the fees.
We can't.
We can't? Well, shit.
I'm not sure.
I don't think the director of finance has ever given money. Well, if we can leave this open.
Can we issue a credit and you'll be back?
Yeah, right. If we can leave this open, then I think, I'm certainly not happy with the decision. I understand where it's coming from, and I understand that you're entitled to it. I think the equitable solution would be that this remains a pending matter.
Pending what, though?
We would not need to reapply if we could figure out, we're not gonna bring up
Oh, I
for the third time.
Maybe we say that this should have never been a hearing, so the 12 months does apply. It should have never been a,
We shouldn't hear, I mean, I think.
Sounds like there's a desire to request a postponement, which the
or,
board is
post,
empowered to grant.
or withdraw the application, perhaps.
I think we'd request a postponement.
Okay.
Or continuance, I suppose continuance is a term of
A
art.
continuance, would this be indefinite?
I think it's the board's pleasure. I'm not familiar with the rule that
So here's-
precludes.
I don't like that precedent.
Here's my question and something that's not clear to me. So let's just play this out as like how we get this parcel back into productive use. So they have a vacant building notice. It's going to require things to the structures that would then trigger our inability to approve it. Does that make sense? Like, I'm trying to understand the connection between once like.
Not necessarily.
Okay.
Sorry to interrupt.
Yeah.
What could happen hypothetically, and I don't want to take up too many people's times because potentially our clients could bring these properties up to a level that would allow for some type of permitted use that's not a long-term intended permitted use. Let's say an art studio, right? You don't need that much to do to. If they can do something like that and get a use and occupancy for that, I think the Burger King's the only one with a VBN. Then they wouldn't have a VBN anymore, and then it would be a different story.
Yes.
Okay.
Yeah.
Okay. All right.
Yeah.
Thank you all for your time.
So you're asking for a postponement?
postponement.
Okay. Sure. Do we want to set a time limit? I don't like the idea of granting indefinite postponements.
We would request 6 months.
Okay, we can request. I'm a yes for a 6 month postponement.
I'm a yes for a 6-month postponement.
I'm a yes.
Oh, so you asked for a 6-month postponement.
Okay.
Thank you.
Thank you, Mr. Harperger. Love punting. It's like the Ravens offense. You know what I mean? So, next question. Calling appeal number 25-134, 5736 Falls Road. Brooke Drew Tilden Esquire, for the applicant. The project is to add entertainment live, accessory to restaurant requiring conditional use approval. First, we will hear from planning and staff. Thank you.
So 5736 Falls Road, appeal number 250134 is a request, a conditional use in a C1 district to add live entertainment to an existing restaurant use. We understand planning understands the proposed hours of live entertainment will mirror that of the establishment's operation, which is 11 a.m. To 2 a.m., 7 days a week, with a maximum occupancy of 49 people. The site is set back from residential uses. It abuts a swimming and gym facility to the north, and the closest residences are across the street and also buffered by some trees. So with that, planning recommends approval of the appeal.
Ms. Tilden, will you be having anybody speaking? Providing testimony? If anybody is here to speak either in opposition or in support of this application, please stand and be sworn.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Thank you. Tell us why you're here today.
Good afternoon, Mr. Chair, members of the board. Thank you so much for having me. Drew Tilden, Rosenberg, Martin, Greenberg. I'm here on behalf of the applicant, and I'm joined today by Mr. Chip Watkins, who is a representative of the applicant. I'm just going to provide a little bit of background, but as you know, we're here today requesting approval for accessory live entertainment on the property, which is an existing restaurant with outdoor table service. As background, just so that we can, and thank you to the BMZA staff. So the property is located on Falls Road on the west side, and it's just south of Kelly Avenue. It's in the C1 commercial corridor along Falls Road. Other longstanding businesses in the area include the Mount Washington Dry Cleaners, Pizza Voli's, Kebab Stop, DMS Salon, and also Joe's Bike Shop. And then this lot is also just east of Copper Mine's new Copper Union Pickleball Complex. And that is, well, you can see it right there, right behind the property along Kelly Avenue. So the existing approximately 1,500 square foot improvement is did operate as the curb shop for over 80 years until it closed down in 2023. And then last year, the applicant reopened the space, which was beloved as part of the community, as the Copper Cafe and Sound Bar. So the restaurant offers a diverse selection of shareables, pizzas, handhelds, and then there are also TVs and vinyl records and bar games. So this operation is not sort of formally part of the Copper Union complex, but the Copper Cafe and Sound Bar is a member of the Copper Mine family, and it shares parking with the facility via a footpath along Kelly Avenue, and I've included a parking map in your files for reference. So today, the applicant is seeking to enhance the patron experience by offering live entertainment, and that's going to be consistent with the restaurant's focus on both sports and music. Acts are going to include 1 to 3 musicians, a DJ, and live podcast recordings, and the entertainers are going to be located in the rear of the building. And I've included a floor plan for reference as well. The existing restaurant sound system is going to be used for DJs, so music is not going to be audible outside of the building. Business hours of operations are going to remain the same, with the exception that they might add Mondays on. So right now it's 11 a.m. to 2 a.m. Tuesday through Sunday, and it might add Monday. The building is already equipped with exterior safety and accent lighting, and the applicant intends to maintain it. And as you can see today, the applicant did share its plans with the Sabina Matfeld Neighborhood Association at the October 15th, 2025 meeting, and the group offered no objection to this application. Just to briefly address the relief requested, accessory live entertainment is a conditional use requiring board approval on the property in the C1 district. Restaurants are permitted by right. I'll also note that the accessory outdoor dining is also permitted by right because this use does not adjoin a residential zoning district. I have provided an extensive written explanation of the Schultz standard. I understand that the board is familiar with it, so I will not belabor the issue, but Maryland case law does require that conditional uses be presumed to be permitted in a zoning district absent some showing that the use is going to have adverse effects at this location above and beyond those inherent to the use at any other location in the zoning district. So in this case, the C1 zoning district. For reference, the C1 Neighborhood Business District is intended for areas of commercial clusters and pedestrian-oriented corridors that serve the immediate neighborhood. I'll also note that they are intended to ensure compatibility with neighboring residential uses and to maintain the proper scale of commercial uses. So just sort of addressing now the Schultz v. Pritz standard in relation to the Baltimore City zoning code. The just under 3,000 square foot property is improved by a 1,500 square foot building. It's operated for over 80 years as a restaurant. And the size of the site and the improvements are consistent with the C1 district's intent to maintain the proper scale of commercial uses that are adjacent to residential communities. And now, while the code does not require the operators to provide off-street parking spaces for the accessory live entertainment, and the use itself will not create additional traffic, the applicant is going to still encourage guests to park in one of the nearby parking lots to mitigate any impact on off-street parking and loading patterns. The property is located on the Falls Road commercial corridor, and to the rear, as I mentioned, does abut the copper mine use. The lot is surrounded by commercial uses, and the proposed scale is consistent with the surrounding neighborhood. The requested conditional use, therefore, will not have any negative impact on future development in the area. The proximity of dwellings cannot give rise to a negative impact above and beyond that which is inherent to live entertainment elsewhere in the C1 district, because the C1 district is actually intended for commercial areas that abut residential districts. This is already accessible for emergency vehicles. It's not going to impact light, air, or sound or light or air to the premises. The proposed accessory live entertainment, it doesn't require facilities beyond what is already there for the restaurant. There's no impact on historic landmarks. And again, the character of this neighborhood is residential, and it's already on the commercial strip that's serving this residential community. In terms of the master plan, the plan classifies the property as predominantly pedestrian-oriented commercial, and that's consistent with the C1 zoning. So this proposed live entertainment, which is presumed to be valid on the property under the zoning designation, is consistent with the master plan. It's not located within an urban renewal area, and this restaurant use is permitted by right. No further zoning relief is requested, so it still complies with the applicable standards of the zoning code. This approval does not run contrary to any of the 8 purposes set forth in Section 2-101 of the zoning code, and it actually specifically promotes the quality of life for current and future generations because it's offering a walkable amenity that's not presently available to neighboring residents. The live entertainment, it's proposed to take place within the existing structure and utilize the existing sound system, so there will be no, and certainly no substantial, additional exterior impact from this use above and beyond what's already there in the long-standing restaurant use. And now just to address the limited criteria for denial. So as I've mentioned already, the applicant has shared its plans with the local community association, which has offered no objection to this application, and the establishment of this live entertainment, which again this property does not directly abut dwellings, is consistent with the character of the neighborhood, and it is going to foster neighborhood-oriented commercial uses while also ensuring the compatibility with nearby residential uses, which is the C1 district's intent. So it's not going to have a negative impact on the public health, security, general welfare, and morals, and certainly not one above and beyond what is inherent to the live entertainment use anywhere else in the C1 district. The property is not located, again, within an urban renewal area, and it's not precluded by any other law, the live entertainment. It's not going to measurably increase external impacts, so it is not contrary to the public interest. And then finally, sort of for the reasons already stated earlier, this is in harmony with the stated purposes of the zoning code. So for these reasons, of course, we request that the board approve this application and welcome any questions.
Any questions?
No questions.
Sir, are you here today in opposition?
No, he's in the neighborhood.
Okay, nobody here in opposition. Well, accepting the testimony.
I'm sorry, was it discussed, the letter, like you agreed to the conditions in the letter?
So I am not aware of, and I will admit, my colleague was at this meeting, but my understanding was that we presented our proposal. I don't believe that there was any agreement at any point to condition these on them, but this is certainly the plan for operations.
Yeah, I think.
I'm sorry, would you, I guess, in your microphone and then to get your name for the court reporter?
Am I live now?
Press the button. And when it's green,
My name is Aaron Levin. I live on Matfield Avenue, which is directly adjacent to the location in question. We did have a very productive meeting with the principals from Coppermine and one of its attorneys, and I have handed out a sheet of my understanding of what came out of that meeting, which is basically in alignment with what you just heard. Our concerns were always two: number one, sound or noise, and number two, parking. And so both of those have been addressed, I believe. And we are, as a community, we are willing to support this this permit going ahead.
okay. So after hearing the testimony today presented to me, and reviewing the application, and accepting today's testimony, I do not believe that the establishment of a live entertainment use at this restaurant would cause, with the conditions and under the circumstances as described here today, will cause any adverse effects that would go above and beyond what a live entertainment use would have at any other place in the zoning district. And so because of that, I am a yes for the application.
Also, yes.
Yes.
I'm also a yes.
Also, yes.
Thank you.
Thank you so much.
You all good?
I could do it.
Okay, we'll take 5. Now we are back on the record. I want to call.
Back on the record at 2:23, sorry.
Yeah, now that we're back on the record, I want to call Appeal 25-157. Mr. Preto, I understand that there is a postponement for this case?
Yes, Mr. Chair, Nate Pretel, the applicant for PL 25-157, and after some
Nate needs to be sworn, correct? Have you been sworn already?
I have not.
But it's not a hearing. Come on.
All right. Just make a request for postponement of 2 weeks to allow for further community discussions. I believe there's some interested parties here. They're not opposed to the postponement. We
Okay.
look forward, and if possible, to be on November 4th.
Okay.
Yep.
I'm willing to grant a postponement. Mr. Preto will work with staff to get that rescheduled,
Thank you.
within 2 weeks, hopefully.
Thank you, Mr. Chair.
No problem. Do we need a vote on that?
Do we have the sign-in sheet with the people? So I'm assuming the people who are the opposition, you've all signed in, so we have your information to make sure that you've got the dates.
Okay, awesome. Thank you so much. Now I'm calling Appeal 25-146, 6210 Pimlico Road. Dino LaFiandra for the applicant. The project is to construct a detached dwelling on the property requiring variances to bulk and yard regulations. First, we will hear from planning and staff in this case.
So for 6210 Pimlico Road, the request is to construct a detached single-family dwelling that will require variances to the bulk and yard regulations of Table 8401. The variances required will be for lot coverage in the R1E zoning district. Structure may not cover more than 25% of the lot area. The proposed structure would cover approximately 30% of the lot. For maximum impervious surfaces, no more than 40% of the yard may be occupied by an impervious surface. The proposal includes a 59% impervious surface coverage. And finally, a minimum rear yard of 40 feet is required in the R1E district, and the proposed dwelling will project to within 30 feet of the front lot line, so a 10-foot variance is required. Staff notes the property recently underwent a lot line adjustment due to subdivision process, which added approximately 3,000 square feet to the lot. The dwelling unit is located immediately adjacent. It abuts to the north a large institutional structure, which is a place of worship. And it does experience about a 12-foot elevation change from the front of the lot to the rear of the lot, though that is a common condition for the block face. So with that, planning has no objection to the approval of the appeal.
Thank you. Council, will you be will anyone be speaking in support?
Yes, I think that they should be sworn.
Yes. Please stand and be sworn.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Mr. Chair, I think we'll get names as they speak.
Yes.
Thank you. I'm here today representing Aaron Simca and Margaret Gross, who are the owners of the property at 6210 Pimlico Road. Thank you to staff for bringing up the aerial. The existing house, which is immediately adjacent to the fenced-in area, it has been demolished. So it's actually just a vacant lot at this point. But and the property did recently go through a lot line adjustment where it essentially acquired much of that fenced-in area to bring the property into kind of an L configuration that wraps around the corner of that synagogue, which is right there, immediately to the right of the property there. So the proposal is now that pardon me, thank you. The proposal is now that the former existing dwelling has been demolished to rebuild a new single-family dwelling. Mr. Gross is present. He's sitting over here at the table, and he has a very large intergenerational family, which is driving much of the development program that has been undertaken for this project. Just to round out that discussion, he has 6 children and obviously a spouse. In addition to that, he has a mother-in-law who requires care and a brother-in-law who likewise requires care. So there are quite a number of people who will be residing in this house. We did submit architectural drawings and floor plans of the house, which has a 4,200 square foot footprint, floor plate on the first floor. So there are 3 variances that are requested. The first is for, there are 2 related variances, the lot coverage, 30% in lieu of 25%, seeking a impervious surface area variance of 59% in lieu of 40%, and a front yard setback of 30 feet in lieu of 40 feet, which would be permitted. These factors are driven largely by two peculiar conditions on the site. The 12-foot drop in grade from the rear of the property to the front of the property. While I understand that each of the 4 or 5 houses on this block do experience the same drop in grade, it is somewhat unusual and unique in the zone for that condition. And so we believe that that is, at a minimum, a exceptional circumstance, if not a uniqueness pertaining to this particular property, which is driving much of the design of the site, which you've seen on the material that I handed out. The single page which I handed out is the site plan, which shows the lot and its configuration, in particular the required building setbacks, and also it does have the topography lines. And it shows that there is a significant drop in grade over the roughly 185 feet from front to back of 12 feet. So that's a very significant drop in grade. And that does drive much of the impervious surface on the site, things like walkways, patios. There's a patio that is proposed, which is shown on the plan. This is the only flat area on the entire plan. So that would be obviously necessary for the outdoor uses on the site, whatever it might be, recreation or outdoor activities that might occur. The architect and the surveyor are present, and they have done everything they can to minimize the amount of impervious surface and retain the pervious areas on the site. I did want to point out that there's a significant 75-foot setback, I would say about 40 feet of which at the rear yard is unimproved and is open, and that will be a grass area. I also wanted to point out that the lot has a shared driveway with the adjoining property. And you can see that at the bottom of the lot, kind of the south side of the lot. That comes in, obviously they can't park along that driveway, which does create the need to create a parking pad, so to speak, right behind the property, which obviously drives the amount of impervious. And likewise, if you look at the front right of the building, there is quite a bit of hardscaping there, which is required to provide an entrance to the lower level. Given the grade and the dropping grade, particularly up at the street, that hardscaping, you can see the steps that are there outside of the building envelope. That obviously contributes to the impervious surface as well, and that's required in order to achieve an entrance to the lower level. I believe that there are a number of uniquenesses and exceptional circumstances which I've pointed out, which would satisfy that aspect of the 5-308. In particular, the drop in grade, the location right next to this playground, which is here. I should have mentioned that that as part of the lot line adjustment with the synagogue, who sold Mr. Gross the property, which he added to the lot in order to make a suitable size property, contains an easement for the synagogue to approach to use the area on Mr. Gross's lot for access, for maintenance and repairs of the playground. So there are certain factors here that are all pushing the development area, the buildable area, towards the front of the lot. Not to mention the fact that that's naturally the most usable area because it's the widest area. So those are the unique factors, and the practical difficulty obviously has to do with the need to provide these hardscape features, these accesses, these driveways, and a usable outdoor recreation area
which impacts the amount of impervious lot coverage and the lot coverage ratio presented by this particular building. The purpose is not a desire to increase the value or income potential of the property. It is merely to provide adequate residential space to accommodate this large intergenerational family. I should mention also that Mr. Gross's mother-in-law requires a single-level living, and so she will have a bedroom which is on the first floor of the dwelling, which has a direct impact on both the lot coverage created by the building itself and on the impervious surface. So if that were not necessary, they might be able to create a more compact building or with less lot coverage, but that is in fact a factor that is driving the lot coverage ratio. The variances will not be injurious to the use and enjoyment of other properties in the immediate vicinity. There should be, as a preliminary matter, the synagogue sold much of this expansion land to Mr. Gross in order to accomplish this. And he's certainly maintaining the side yard setbacks and even the rear yard setback where that's possible. It's just where these unique factors are really pushing the development of the property towards the front that we are seeking the variances. And the rest of the development program for this lot really respects the adjoining properties. The variance is not in disharmony. It is certainly not in disharmony, and it is in harmony with the purpose and intent of the city code. There are no city code or comprehensive master plan objectives that are impacted by this proposed variance. We are not in a historic or architectural preservation district or an urban renewal plan area. And the variance would not be detrimental or endanger the public health, safety, or welfare, or be contrary to the public interest. To the contrary, I think that this plan provides an opportunity for a large intergenerational family to locate in this area, which they are quite fond of. They want to remain here. Mr. Gross and his family are members of the adjoining synagogue, and this will be a very good placement for this house in light of the variances that they're seeking and the location right near this synagogue. So, and in this neighborhood overall. So perhaps there are some questions, but that's where I'll kind of leave it at this point.
Any questions? I certainly, I have reviewed the plans and seen the map, the location to the adjacent place of worship and the restrictions, including the easement on the property. I can certainly see how that can make, how the code can cause some practical difficulties. Those are unique attributes, including the slope. So what I want you to do is walk through sort of how the nexus between the uniqueness and the practical difficulty for each variance, starting with, I think the most clear for me is the front yard setback.
Yes, sir.
Could you really, sort of speak to how, again, why you have to build more towards the front of the property?
Yes, sir.
And
so starting with...
Yeah. Before you continue, I'm going to add to that. I'm also interested in understanding the other areas and other setbacks that you're looking for relief. So I know you verbally explained it, but just looking at your site plan, the front is the most extensive part.
Yes.
But there also seems to be some side yards as I look at your
In
site
terms of
plan.
yard relief, the
Yes.
front is the only place that we're seeking relief. The other
Okay, so I'll let you
setbacks-
go through that, and then I'll ask a
Yeah.
follow-up question after you get through those then.
Sure. So, with regard to the front yard and the practical difficulty created by the slope and in fact, the requirement to get in for the school and the synagogue to be able to get in to access that playground from this side, those factors create a practical difficulty in that they require the architect and the civil engineer and the surveyor to focus on the development of the property in the front because of, for two reasons. Number one, there's with regard to the easement, they need to be able to get in there. That's the first point. But also, the front is really the buildable area of this lot. Because that's the widest area, and the fact is that they need to build a somewhat large house in order to accommodate this family, which is a permitted use under the code. And so focusing on the front brings the front facade of the building closer to Pimlico Road. I would also note that under the zoning regulations,
It's also flat.
there are a number of, here we go. We're in the R1E zone, and that typically for new development, the front yard of an R1E zone is required to be 30 feet. And it's different here because we have a developed block face. And when you have a developed block face, you have to follow the footnotes and go down, and there's a little bit of a discussion here, but in this particular circumstance, because we've got a developed block, the setback is 40 feet as opposed to 30 feet. So a 30-foot setback is not unusual in the R1E zone. It just happens to not be the requirement at this location. And I did want to follow up on Mr. Marcosi's question. The only place where we're looking for lot setback relief is in the front yard. We're not looking for lot setback relief on the side yards or the rear yard.
Okay, thank you.
Now, Mr. Shelton, would you like me to address the other variances in the practical difficulty?
So let's go through impervious coverage.
Yes, so the impervious coverage is driven by the practical difficulty created by particularly the change in grade from front to back. It creates a need to, for two particular things in this case. Number one, in order to have any flat outdoor area, they need to grade and have a patio. So that creates a need for a patio, which is impervious on this plan. The second thing is in the front, in order to achieve, given the slope, in order to achieve an access to the lower level, they need to have significant hardscaping right in the front, which is impervious. So that's outside of the building envelope, but it is impervious area, which is a result of the need to navigate these different slopes and create the space in order to get into the lower level. And then I also wanted to mention, because of the shared driveway and the slope coming up from Pimlico, they need to, they can't obviously park on that driveway. They need to have a separate parking area, which is obviously needs to be paved, and that's impervious as well. And that is located behind the house. So, so for those reasons, I believe that that is the practical difficulty in achieving those design objectives created by the slope of this particular lot. And then lastly, as it relates to the lot coverage, which is really just a measurement of the building floor plate on the lot as opposed to the overall impervious surface on the lot. That is driven in this particular case by the need to have it's driven at least in part by the need to have bedroom on the main level for Mr. Gross's mother-in-law, who requires care on one level. And for that reason, and that's shown on the architectural floor plans, which I handed out, but for that reason, that drives the building envelope size, which is creating the need for that lot coverage variance. So, and I would assert that that's a exceptional circumstance pertaining to the structure.
Okay.
In satisfaction of the code.
Could you discuss alternatives that you guys consider that would have minimized the need for any of these variances?
Yes, sir. So, number one, they did in fact implement an alternative or a design feature, small as it might be. I did want to point it out that if you come up the driveway and you see where it says proposed paved driveway, there's a landscape island right there. And they did that in order to have some pervious area right in the back, right there. And that could, I mean, under a different development program, that might have been an open section driveway leading from the ramp up to the parking lot. But they did in fact put that pervious landscape island there in order to achieve to minimize the amount of impervious that they were required to do. My understanding as well, and perhaps the technical people will chime in if they feel that they'd like to, that other design features were added that kept as compact a building as possible in order to minimize the lot coverage and the impervious surface generated by a house of this size on a lot of this size. And I don't know if anybody wanted to comment on that further.
Well, I do have a question that I would love, I think, in terms of technical comment. Did you all consider anything like permeable pavers, at least for the patio area and potentially the parking area? And if that wasn't an acceptable solution, maybe walk me through why.
And Mr. Chair, if I could ask, when you speak, if you could say and state your name.
Yeah, Stuart Macklin, yeah.
How do you spell Macklin?
Macklin, and Stuart is Stuart. Yes, that's a possibility, without a doubt. To have that both in the front entrance to the basement, which has considerable area, and the back patio area, both could be done with impervious material. Pervious material, sorry. Mm-hmm.
And I mean, you only need a 5%. How much? 19. Well, that would minimize it. That might not eliminate the need for the variance, but would it significantly minimize it? Would you guys be willing to consider making those adjustments?
Yeah, we talked about that.
Yes, sir.
Okay.
Yeah.
One more?
Yes.
Mr. Dallas.
Scott Dallas, D-A-L-L-A-S. Another item that drives the need for this is a height restriction.
Yes, sir.
And we are staying within the 35-foot height restriction, but it really gets rid of the possibility of a third floor, which may give us the overall square footage, but we can't do it.
And
so there is some significant basement areas also for the kids kids use as well down there, but the rear patio is really what we need for an outdoor recreation area.
Thank you for pointing that out.
Yeah, I think for me, the compromise in terms of like permeable pavers where they can work architecturally makes, if we can eliminate one of these variances, kind of opens up an understanding around some of the ones that are more difficult to overcome.
Yeah. Do we have an understanding of how much impervious area would be removed if we were to include those pavers?
I think we talked about that. About patio was 400 square feet itself.
Okay.
But I don't know the percentage in relationship to the 400.
We'll probably get around 1,000.
Okay.
In total.
I have a couple questions. I just want some clarification. I think obviously the pervious pavers are going to help out significantly with some of the concerns that the board may have. But could you explain, just looking at your site plan, And I understand that the building restriction line you're drawing is pretty much identifying the setbacks required, or the setbacks that the site has. I'm specifically concerned, you explained the front well, on the side yard where the rear patio is extending into the setback line. Is this any area of any concern, a buildable patio that may be in conflict with the zoning code? That's one of my questions. I see a set of stairs or two sets of stairs, possibly a retaining wall. What type of construction is that? And I'm sorry, Mr. Williams, it might be helpful if we can maybe show this site plan on the screen.
I don't know if, do you have that?
I just want to make sure that if everything's going to get approved here, this is not going to get caught up in any building permit issue that you guys may confront if we get approved this.
We're talking about a garden wall and a patio.
So if that could
That's-
just extend on the building line?
Yeah, but that's, isn't that allowable?
Gentlemen?
Pardon? Are we waiting for a site?
Yeah, I think we're waiting for the site plan, but if I may, perhaps I can ask a question of the witness. Perhaps it's you, Mr. Macklin. Is the patio lower than the grade at that point?
It's 4 feet lower.
It's 4 feet lower than
And
the
we have a
grade.
garden wall retaining wall to
Yes.
protect it there.
So where we're showing steps, those are steps down
That's
from
correct.
the grade to the patio?
That's correct.
Okay, and
Because the patio aligns with the finished floor of the house.
yes, and is there there's a retaining wall, but does that extend up above the grade, the retaining wall?
It does, about 8 inches or so, but after that, it's just a protective, open, wrought iron fencing, architectural fencing that protects from people from falling down.
Okay. And Mr. Marcosi, I think I understand your earlier question about the setback. And when I had looked at that particular issue, given the fact that it's a patio, especially that it's sunken, I did not believe that we needed a variance from that particular feature there.
And you may not, I just want to make sure that you don't.
Yes, thank you.
And then the same kind of question happens along I'll just say this, I guess it's the north is facing up, but the southern part of the site. Driveways coming in, I'm not quite sure if that's identified as a retaining wall, if that is intended to be in a retaining wall that separates the drive aisle from the landscaped buffer area.
Yeah.
Also a similar concern if that's actually required to have some type of relief from the setback.
Those are good thoughts. So, Mr. Macklin?
No, those are not retaining walls. That's just a landscape area to on grade.
Gotcha, thank you. And then the final area of concern is where you have your sukkah at the rear. Is there any built construction there?
Where?
Where the sukkah is identified right there?
That's an on-grade flat plane. That's just a grassed area.
Just a grassed area, okay.
That's correct.
Okay, thank you.
And Mr. Macklin, is there a retaining wall around that as well?
It's nothing more than a small curb,
Okay.
about 6 inches high.
Okay. And while we're asking questions, Mr. Dallas, was there, you had mentioned you think we could achieve about 1,000 square feet reduction in impervious area if we use pervious pavers. Does that include pavers for the patio, which is labeled at 585 square feet, and that front area with the parking?
Yes,
Yeah.
we'll probably exceed 1,000, but we would have to work it out between Mr. Macklin and myself.
Okay.
So my final question, really, and this goes to the board as we kind of get into deliberation here, is that the proposed patio and covered area, is this area that's outside of the setback or within the setback going to be identified as allowable per the zoning code? And the same thing happens, my same question is concerned with the sukkah area. If we have a curb there, understanding what a sukkah is that going to be identified as a structure? Because, correct me if I'm wrong, this is only a temporary structure that occurs during your holiday season?
Correct.
Is that acceptable to the zoning code? Sorry to raise these questions, but I just want to make sure that if we get past here, that these are not going to be caught up in your building permits.
Hard copy to be provided of the zoning code. I have it, so I need to look it up. It'd be the permitted encroachments section in table 15, 601, I believe.
I know rear patios up to a certain extent are allowed, permitted encroachments. I'm not sure about front.
The rear patio can be open.
Yeah,
It
open.
has to be open. It's an open
open.
patio.
Yeah,
It is
right.
open.
Yeah.
Yeah, it's
I,
allowed as
I feel like we've had a case before with the sukkah, and it was considered temporary. So
I mean, it is temporary.
it is
8
temporary,
days a
yeah. But I
year.
mean, I understand you wanting to check all those boxes. But I feel like it was a consideration similarly where it was whether or not it was a different question, but ultimately we were arrived at being comfortable with calling it a temporary structure.
It's all fine to me as long as these don't conflict with any of the zoning codes.
Sure.
Believe the provision would be, well, either the patio terrace if it's open. So I think the sukkah would probably qualify as a patio terrace as shown on the plan. And then the front yard porch provisions would be here if it's unenclosed.
With or without, okay.
But I don't know if it is, well, I guess enclosed means like the front, like a screening or something, but if it's just a roof. So I guess there's a question back to that, as long as the applicant's asserting and testifying that they don't need the variance, then we'll take their assertion.
So I'm not quite sure what it is that you're suggesting.
I think the question, I think the question trying to confirm is does the porch and patio in the front and rear meet the permitted encroachments provisions here so that they don't require another setback variance? And so it sounds like, well, I trust you all have done this. I think he's just double checking.
I'm just double checking. That's all I'm trying to do. And just understanding the what the intentions are with the sukkah, making sure that's just.
Yes, the sukkah is a temporary structure, and so I don't believe that there's an encroachment issue with the sukkah or the patio, because I think that it is permitted under the permitted encroachment section here. The one point that I'm not clear on is the degree to which our encroachment into the 40-foot front yard is due to a permitted encroachment, which might reduce the number of variances we need. So, Mr. Macklin, how?
Well, there is a front porch on there, and if that is considered right now part of it, that is an open front porch.
Do you happen to recall the front to back width of the front porch?
Let me see. Okay. And it's not on this one. I think it's 10 to 12 feet from front to back.
Okay.
I don't have the exact dimensions on it. It's on a detail sheet.
So that would mean that we do need I believe that means that we would need a variance to have it be 30 feet, because that would mean that the front building face is less than 40 feet from the front yard, from the Pimlico Road.
Make sure you understand the 30 feet there shown is to building. The porch is to move your arrow up just a bit. The porch is right to the, I can't describe it for you. But that is, the 30 feet you see there,
Yeah, I see the 30 feet.
that is to building.
Okay.
Is that that's not to the porch?
The porch is to the side of that, where the steps are.
Oh, I see.
Right there, that.
Right there,
Okay.
that's the porch.
That's the in-law suite.
The 30 feet just to the building.
I see.
That's the in-law suite, so.
That's where the in-law suite is, yes.
Yeah.
You swear, you want to state my name? Aaron Gross. Okay. Gotcha. Yeah, that bump out is for the in-law suite, and that's the only part at grade for the entrance, so that they can walk and then go through the whole house without any stairs. So that's
So if I'm reading this correctly, shouldn't the setback, then if this is part of the house, isn't the setback?
No setback.
No, that's not the part of the house.
Okay, the in-law suite's completely, in-law suite is separate?
That is a porch right where your hand is right now.
Okay.
And that is a walkway down to the basement,
Okay,
and that's all open.
okay.
Where's the in-law suite?
Lower down where it says the 30 feet,
The 30-foot arrow
Right there.
points to
Right
the
there.
in-law suite.
Oh, okay.
because that, on the side, right where it says.
Oh, so it's not a porch?
That part's not the porch.
Okay. Well, that didn't work.
But that's where the grade, that's the only way where she can enter from the driveway without any steps. And the whole house is at that grade, the whole first floor is at that grade.
Okay. But because the in-law, the livable area on the first floor definitely abuts the front yard.
Yes, sir.
So there will be a need for a front yard
Yes, sir.
setback. From our understanding of the testimony, what we heard today is due to height restrictions, due to grade, elements of the grade, and other conditions on the property, there is a need to have more livable area on the first floor.
Yes, sir.
So in order to accommodate the mother-in-law, I believe.
Yes, sir.
So just to make sure that's the reasoning for that
That is correct.
variance.
Yes.
Okay. Any other questions?
I do not have any other questions.
Okay. All right, let's time to deliberate. So we have 3 variances before us. I guess,
If I may, I'd also draw your attention to Mr. Walker's staff report, which he lays out the factors which you can adopt if you are so inclined to save yourselves a.
yes. I want to start with the front yard setback. Are there any, do we have any problems with the justifications offered for the need for the front yard setback?
I do not.
Yeah, I'm inclined to also be willing to allow the variance for the front yard setback. We've heard a lot about the easement and the grade changes and how more of the front of the property has to be built on in order to accommodate those changes and still allow enough livable area for the family. And so I'm inclined to be a yes for that variance. But before we get into the factors, I want to make sure we just talk about the uniqueness and the practical difficulty of these variances first. Impervious coverage, anybody have any issues with the justifications offered for this variance?
I think the question about the change in the impervious surface was answered.
Yeah.
And understood that it would be less so.
What wasn't made clear though was with the 1,000 or so was what I was thrown out as an estimate. Would that be enough to remove the need for the variance? That calculation wasn't done. Is there a way somebody could do that now? Just because if that takes it off the table, that really helps.
Maybe reduce it, I don't think I'll take it off.
Yeah.
Alternatively, the board could propose to condition the approval on the pervious pavers being installed.
Yeah, we could
480
approve
square
the
feet for the patio
variance,
as well.
and make just the condition that
That part
it
right
will
there.
be using.
Yeah, because even without it, I do think that
486?
896.
there was
No, I'm just
justification
talking about this
offered
one.
for the need for it.
This?
Okay.
That's a slab. I'm sorry.
Do you guys have an answer?
Just a second.
All right, even if you don't, we're gonna continue to deliberate. So, once again, the conditions, especially of neighboring properties and the restrictions on that, and also the needs of the family living inside the home, sort of necessitates more paved or covered area on the lot. I was, very heartened by the grade changes, the need to have some sort of outdoor livable space, but due to the grade change, there has to be a patio and some paved areas. Also hearing about the need to have due to the height restrictions, you know, you sort of have to pick your poison. You know, which one do you want to get a variance from? You decided to instead just use a little bit more of that lot in order to make sure there's enough first floor space to accommodate the family. And you know, I am, you know, you know, and also the willingness, I think, of the applicants to minimize the need for the impervious coverage variance to the extent that they can using pervious or permeable pavers. I'm likely to also, you know, find that the code imposes a practical difficulty to comply with. Proposes a practical difficulty that is due to the unique circumstances of this property, or exceptional circumstances of this property. And I find, for the same reasons, the maximum lot coverage is also justified. Does anybody have any problems with that? So for those reasons, and also the application, and you know, accepting the arguments or the statements in the report from Planning Department, I find that all the conditions are met for variances here in these circumstances. The unique conditions of the property and the exceptional circumstances of the property create a practical difficulty with compliance with the code, and the applicant has proposed a well thought out proposal that minimizes the need for variances for all these three variances as much as possible. And so for those reasons, I'm a yes for all three variances.
Also yes for all three variances.
I would say yes with all three variances, with a caveat that the 19% will be maximum on impervious surface. Or less. It will be 19% or less.
More or less.
I'm also yes for the same reasons.
Also yes.
Thank you, guys. Appreciate it.
Thank you very much.
Now calling today's winner, Appeal 25-148, 1108 Harlem Avenue. Vicky Mabry Height is the applicant.
Thank you.
The project is to use the property as a multifamily dwelling, 3 dwelling units, requiring variances to the bulk regulations. First, we will hear from planning and staff. Followed by that, we will hear from the applicant. As a gentle reminder, I know you've already seen it many times. Please stand and be sworn, and state your name before you speak.
You swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
I take it you're Miss Vicky Mabry Height?
Yes.
Yes, okay. And if anyone else speaks, we'll give your name and spell it at that time.
First, we'll hear from planning and staff.
So 1108 Harlem Avenue, appeal number 25-0148 is a request to use the property as 3 dwelling units. It is an existing multifamily dwelling with 2 dwelling units currently approved. Zoning administrator determined variances will be required. 1 variance is needed, which is for insufficient lot area. For 3 dwelling units in the R8 zoning district, 1,875 square feet is required. The lot currently contains 1,148 square feet, so a variance of approximately 39% would be needed. Planning notes that even if the existing 2 dwelling units for which the property is currently approved for were approved today, that would require 1,500 square feet. So even those 2 units would need a variance if they were currently being approved. Regarding the standards for approval, staff wasn't able to find any peculiarity as the shape, topographical conditions, and structure are consistent with the rest of the block face and neighborhood. And the currently approved 2 dwelling units allows for a reasonable use of the structure. And again, if it was currently approved, the lot area requirements would not be met even for the 2DU. We also understand the third dwelling unit would be placed in the basement, so it does appear to be an attempt to increase the income potential of the property. So for those reasons, planning recommends disapproval of the appeal.
Ms. Height? Please make sure that your microphone is on when you speak. Press the button. Make sure it's green. There you go.
Good afternoon, Chair and members of the board. My name is Dr. Vicki Mabry Height. I am the owner of 1108 Harlem Avenue. I respectfully request approval of a variance to recognize a small basement studio apartment so that the property may function as 3 dwelling units within the existing building envelope. A modest, code-compliant adaptation of a historic row house to meet the contemporary housing needs. The home is a narrow 3-story row house constructed prior to modern lot area standards. The property is undergoing full rehabilitation to upgrade structural, mechanical, electrical, and life safety systems. The proposed configuration is Unit 1 basement studio apartment, 1 bedroom, Unit 2 a middle floor with 2 bedrooms, and Unit 3 upper floor with 2 bedrooms. All units will fully comply with the Baltimore City Housing Code, including requirements for egress, ventilation, and safety. This property holds a profound historical and community significance for West Baltimore. 1108 Harlem Avenue was owned and lovingly maintained by Essie Mead Hughes, who lived in this home until her passing at age 94. For decades, Miss Hughes was a pillar of this neighborhood and a transformative figure in Baltimore City's public schools. As an educator at Western High School and later as the assistant vice principal of Frederick Douglass High School, she taught and mentored 5 to 6 generations of West Baltimore students, shaping countless lives through her dedication to education, leadership, and service. Ms. Hughes was also a classmate of Supreme Court Justice Thurgood Marshall during their time at Frederick Douglass High School. Today, her portrait proudly hangs in the school's hallway as a lasting tribute to her lifelong contribution to Baltimore's educational landscape and her commitment to empowering young people. When Ms. Hughes passed, her niece, Elaine, inherited the property and sold it to me with the expressed understanding that I would restore it and preserve her aunt's legacy. This project is therefore not merely a building rehabilitation. It is a continuation of a multi-generational mission to honor an extraordinary educator and civic leader while ensuring that this home remains a source of pride, stability, and inspiration for the Harlem Park community. Practical difficulty. The property measures 13 feet wide, 85 feet deep, total area 1148 square feet. This includes a full height basement aligned with existing plumbing and stair systems. Because of the narrow footprint and vertical layout, merging the basement with the first floor would compromise safety, accessibility, and livability. Allowing the basement to function as a self-contained unit is the most functional, safe, and reasonable use of the existing structure. Under the variance calculations, the required lot area for 3 units is 750 square feet per unit, 1,875 square feet. The existing lot area is 1,148 square feet. The previously approved variance of 352.5 square feet in February of 2024 made the effective approved lot area 1,500.5 square feet. So the additional variance request is for 374.5 square feet, or approximately 19.97%. Requesting an additional 374.5 feet to allow a small basement studio, combined with prior approval, total relief equals 38.8% from the strict requirement. The property's size and shape are original historic conditions, not created by me. This request is driven by the goal of bringing existing space into compliance with life, safety, and housing standards, not merely an increase in revenue. The proposed studio remains modest and compatible with residential character of the Harlem Park 2 district. No exterior changes are proposed. The existing height, footprint, and facade remain unchanged. A professionally managed, fully permitted 3-unit dwelling will stabilize the neighborhood, improve property conditions, and reduce the risk of over-occupancy. The request maintains the structure's existing form while improving safe, compliant housing options. It aligns with Baltimore's goal of supporting gentle residential infill, adaptive reuse, and reinvestment without altering the block's scale. This property is not located in a CHAP district and is unaffected by any urban renewal or comprehensive plan limitations. The proposed change is limited to an interior reconfiguration. All construction will meet the building, housing, and fire safety codes. A well-managed, properly permitted 3rd unit enhances neighborhood safety, reduces vacancy, and contributes to the public good. However, due to the high cost of comprehensive rehabilitation, a 2-unit configuration would not render the project economically unsustainable. A 3rd unit is essential to amortize costs and ensure long-term viability. Granting the variance will prevent the building from remaining vacant or underutilized, increase the tax base, add quality rental housing options, and advance the city's policy and objectives surrounding revitalization. Voluntarily, so I'm asking that this board will approve this with the information that I provided. No one is here today contesting this 354 square foot inclusion. I've provided an architectural drawing of the existing basement configuration. The architect, Mr. John Carter, is here if anyone had any questions on that. But the egress and windows meet the applicable life safety requirements. The layout maintains existing plumbing stack and alignment for efficiency. For the reasons stated above, practical difficulty, unique pre-existing conditions, consistency with the zoning code's intent, public benefit, and minimal neighborhood impact, I respectfully request approval of the additional 374.5 square feet, 19.97% variance to allow 3 dwelling units within the existing structure. Any questions?
There's been no UNO on this property since, it's been vacant since 2007.
Yes. The last owner was Miss Hughes.
And there is still a violation, open violation from 2011 on this property, correct?
That is a vacant building, and I'm trying to deal with that, but I can't do anything without permits. I worked on it, what I could do, I did a small permit for like the roof, because it was gonna fall in. So I spent $58,000 for a new roof. And there was some stucco work that needed to be repaired outside. So I spent $28,000 to repair stucco and paint the outside. But I can't do anything really constructive without approved permits.
This property doesn't have any type of historical designation to it, does it?
It does not. It's just considered in a historic district. The Harlem Park area is considered a historic district, but the building itself is not.
And it's still set up as a 2-unit multifamily dwelling.
They don't use multifamily, I don't believe, with 2 units.
Well,
That's
it's a
considered a
2-unit
single
dwelling.
family. It's always been 2 units, because she lived in one and rented the other.
Okay. And that's what exists today.
That's what exists today.
To get 2 dwelling units, for example, if we wanted a lesser of a variance, there will still be insufficient space. So what you're asking for is to do an additional unit on top of, what's there is non-conforming. So you're asking to add to the intensity of the non-conformance.
That's not really what I'm asking for. The board already approved previously something, and that's not an issue today. I'm not reopening that case.
So
I'm asking for 354 square feet for the basement.
I might be able to, I just have a follow-up question on that I think might answer the chair's question. Since you came so recently in 2024 and were approved for 2 units, why 3 units now when no progress has been made on the building? Like if the intent is 3 units, why not ask for 3 units in 2024?
I didn't know initially whether that was possible. And then when I discussed it with John, he said, yes, it is possible. It could be a studio with the existing space and then the existing footprint.
Well, possible.
I didn't know that was possible.
I think we need to clarify possible.
Oh, sorry.
Because while lots of things are possible architecturally, like in terms of could someone physically stand up in the space or do a certain activity, I think the challenge is that, and I think you've heard from being here a while, is that these variances, they're supposed to be rare. And we've already granted this this property one already in the not so recent past. And so that wasn't enough to create an opportunity for you clearly to get permits and to start work because, and I guess I'm curious, did something happen after that variance that led you to not make any progress since 2024?
Well, one other issue is that 2 units, you can't get any funding for the restoration. And because of the amount of money, close to $300,000 to restore these buildings, you have to be able to secure funding from an independent lender.
Right.
And 2 units are not sustainable.
So I think
it won't support even paying the mortgage note. So I'm trying to secure funding so I can do this building as I promised and maintain it. And I just feel with the basement, that makes the difference.
So what's challenging about that is that it contradicts your testimony. And the way that it does that, and I don't think I'm going to explain anything that you don't understand, but for the record, in order to make this project financially viable, you're telling us that it has to be 3 units and that you cannot pay the mortgage unless it is 3 units. Meanwhile, planning's testimony, and one of the things that we cannot consider is the personal financial situation. in terms of providing a variance. So that can't be one of your reasons, right? We can't consider that. So I think that, we're in a difficult spot trying to get you an additional variance beyond the one that you already granted. Because I think, I would say from a BMCA standpoint, the one that was already granted was significant, just to get the property approved for 2 units. And I know it's always been 2 units, but when it's vacant, you've got to come back and ask for it to be 2 units again. And so that's obviously what you did. And so that's, I think, so it sounds like you tried to procure financing and the math didn't work unless you do a 3rd unit. And so you retained an architect to determine whether or not a 3rd unit was viable. And now you're here today asking for an additional variance beyond the one you were granted in 2024. Am I understanding that correctly?
No, you're not understanding that correctly, but I didn't want to interrupt you.
Okay.
The architect was part of this in the beginning. That's why the initial plans were submitted, and even with the previous variants and plans.
Okay, so in 2024.
So that is false information, the way you've presented it.
Well, that's why you're here.
Second, I'm not contradicting my testimony. In my original testimony, I also mentioned that there's an economic hardship and a public benefit. And so I clearly stated that as part of my initial testimony. That is not something that I had changed or tried to not disclose. Thirdly, this property, I feel, has a historic significance that other properties in that area or that block may not have. I consider that something unique. And I'm asking the board to please consider that and take that into consideration also. So there are many factors when you're restoring a building. And so the historic significance is also one factor here.
Unfortunately, that's not tied to the variance that you're asking for. So even if you went and pursued historic designation, you would still have to, however you wanted to develop the property would still need to conform to the zoning code. So that can't, what I'm trying to help you, we're always here to kind of help guide this information and make sure that you're understanding where we're coming from and that we're not being dismissive of the things that could be true about the property, but just may not be things that we are legally allowed to consider. Does that make sense?
I just feel that another uniqueness about this would be that it'd probably be one of the only buildings in the neighborhood with a rented basement that's done safely and that has a permit. That would also be another uniqueness for this particular project. And I thought on the handout that you gave today, does anyone have the handout? Where it says variance approval standards. On the uniqueness, they have historical significance. I didn't think that meant the building had to be historic. I meant the occupants and the lady who lived there for like 60 years and contributed to this community was historically significant, not the building being a historic building. And I thought that was something unique that could be taken into consideration.
Okay, so even assuming if that the occupant was relevant towards the uniqueness consideration, we still have to find a nexus between that historical significance and the variance requested today. Why is that history causing you to not be able to comply with the zoning code, which, and that's where the tenuous relationship is, because we can't find a way. That's as important as she was to the community, which I believe you, there's no direct tie to how that importance it makes it difficult to comply with the zoning code for this property, assuming that we even could consider it. So what we're really trying to figure out here is, why do we have to relax the zoning code regulations for this property compared to its neighboring properties? What about the structure itself, the property itself? And what we're hearing is that there's economic consideration that's at play here, but it cannot be the only consideration.
Okay. So it would be a storage area. because it really wouldn't be usable by anyone. The basement would be a
Is it due
historical
to
area.
size? Is it due to the size of the basement?
Yes. So that would be one difficulty for me. Without the permit, it just becomes storage, and
Well, could you maybe explain a little more? Maybe your architect could help you out explaining why that could not be used. If you're proposing it to be a dwelling unit, why could it not be used for something else but storage? I'm trying to help you find some uniqueness to the property here.
Building on what he said, I think the question could be, why couldn't that be the basement? Could that be either shared washer dryer for the 2 units upstairs, or could it be?
Please press the mic, sir. Microphone.
And if we can get your name and spelling.
Sorry. My name is John Carter. Easy to spell, right? All the units have their own washers and dryers. The basement unit is a small unit, but easy to live in, I should say. It's enough space for a bedroom for 2 people. There's a kitchen, its own kitchen. It's not it's a full kitchen, and it has its own bathroom, and it's a washer and dryer in a separate area. Mechanical equipment is enclosed. Everything is enclosed. If you want, I have a floor plan.
Yes, sir. We have the plans.
You guys, and it seems like it was enough for what they call a small living, single family, not a single family, but.
Right. So I don't know. No, I don't see how that actually helps the case of trying to find some peculiarity.
The thing is,
Let me try one more time. Try one more time to help. I think where they're getting at is, why couldn't you use it as an extra space for the first floor unit?
Love it.
Why couldn't that be the in-law suite, or just another room and a living area for
Make it 2
tenants? Yes.
Or another bedroom. For
So explain why that's not feasible in your opinion, or why it's better to do 3 units as opposed to 2 units with a larger basement.
Either one would work. I'm designing for someone else.
Sure.
So either one will work, but I don't know. I tell you, when Ms. Mayberry came to me and asked if it was possible to do this, my first question was, the rest of these houses, do they have 3 units in them? And they do. So I said, no reason why it can't be. So that's basically, why.
That's not the standard we go by, though.
but yeah, they don't have a permit,
No,
and they don't have all the safety
All I knew is that
issues.
there's 3 units and all the other units, apartments around there, so I didn't have any real question to say it couldn't be done.
So that would be another uniqueness, that it's a permitted, safely done, with health and safety issues taken into consideration, and appropriate egress for this building.
And to me, it seems that if the code says that this size building can't be used this way, they should look a little bit more closely. I guess people are getting used to living in smaller areas, I guess. I don't know what the reason in the first place a code would limit something unless it was felt that it was not
So the
comfortable.
thread I think that we're all sort of following here, and I want to be clear, I am personally usually very supportive of increasing density in neighborhoods and taking these 3-story buildings and maximizing the space and creating units. Like, I'm on board with that. The challenge is that because this building has been vacant, even though it was used as set up as 2 units for the duration of the use of this building, or at least as long as we know, right? Once that building becomes vacant, it reverts back to the zoning, and that means a single-family dwelling. And so that doesn't make sense. So then came before the zoning board in 2024 and asked for permission for it to just say, can we just have the 2 units? Because that's already what exists. That's how the building has been used. And it required this certain percentage of variance. And the board granted it. I think that's a reasonable argument.
Let me clarify the record. So the action in 2024 was to confirm the non-conforming density or non-conforming structure. So the technically didn't grant a variance in 2024.
Okay.
It's the same result is that you
Okay.
confirmed, you allowed there to be 2 units.
Yeah.
But technically there wasn't a finding for the variance
Okay.
standards.
So it could be 2 units, but the ruling was it couldn't be 3.
I think the request before you at the time in 2024 was just to confirm that there was enough evidence in the history that it
Okay.
had 2 units that would continue. So now it's the first time technically you're hearing a variance request.
Okay.
And I'm also not requesting to reopen a file or negotiate what the board has already decided previously.
I took a look, and this wouldn't, the legislation before the city council about the upzoning, this wouldn't apply, would it? It was because in R8, you would still need 750 square feet per
Do you
unit.
know the interior floor area is what controls for having up to 4 units? So do you happen to know, and it might be in the plans, the interior floor?
You don't have the whole plan with you, do you, John? I uploaded it, but I didn't bring it today.
Approximately 25 by 12 times 2.5. 25 times 12 times 2.5.
Oh, is it 25 or is it, I'm sorry, I'm just looking at your floor plan also, it's kind of hard to read on my side. Is that the,
Because the basement is not a full floor.
right, well, we're not just including the
Right.
basement, we're including the entire building.
Yes.
Plus the half.
That's a half.
Plus the half.
Yeah.
That's half.
Yeah.
So it's 12,
25
your
by
interior
30.
space is 12 by 50, is that correct?
The inside is 12 foot 4 inches, if you want to, and it's 25 feet long. 50, I'm sorry. Did I say 25 before? I'm sorry, it's 50. Make it 48, because that's 50 out.
It's important that we get this number accurate because it would tell us whether or not there's another avenue to perhaps get you the relief you're
Could
requesting.
he do the calculation, John? You said 48.
No. What did I say, was 48?
48 by 12 foot, .4 or 13 feet.
Okay. Foot.
3 times 48 times 20.
How many 330? That's 591.
2.6 units.
595, 595.2.
Times 2.
Yes, it's 48 times 12.4. 595.2.
Are you telling us that's what it is, or we're not gonna?
I'm
sorry, we
telling you
can't-
that that's what it is.
I'm gonna get
I don't know
that.
the
I
significance,
got
but.
591. Let's
Okay.
see, times 2,
Times 2.5, right?
0.5.
Okay.
1,479.6.
Sure.
That's for the entire building, including the basement?
As far as I can,
So the first, second, third floor and a basement?
Yeah, 3 floors, right? And the basement?
No, 2,
So it'll be 3.5?
3 quarters.
Three and a half.
3.5. Gotcha.
3.5. Complete.
Let's start from the top.
How do you? Yeah. Oh,
Right now, just
here we go. 48 times 12.33 times 3.5.
that's the difference.
That's what they're there.
All right, 2,071.44.
And what is the number for the minimum enclosed area?
So what the chair is referring to, there's legislation that's pending, it's Council Bill 25-001, 0066. It's the Housing Opportunity and Options Act. It would allow, by right, multiple units based on the interior floor area, whereas currently the density that you have to calculate today, because that law is not adopted yet, is just on the lot area. As you've described, it's a smaller lot, so you only have the ability to really do one by right. But with this law, if it passes as drafted, then if you had up to, it's lost. For 3 units, you need 2,250 units. Sorry, 2,250 square feet, not including the basement area. That might be a quirky definition if the basement here, if it walks out to the grade off, so then it probably wouldn't count then. But that's the calculation. So that would be another alternative if the board is maybe you
But
could
it would
come,
still
if the board
fall
is not
short.
inclined to approve today, the option could be come back and it'd be a smaller variance potentially from the
So
future interior floor area.
that is true. If this legislation passes, which I believe it passed second reader yesterday in the city council.
This
This
specific,
is the bulk.
the
This
housing
hasn't gone
option,
up
this
yet.
is the Housing Opportunity Options Act. I just looked at the bulking yard. I don't know if it changed the bulking yard for R8.
It seems that in either scenario, you fall short. However, if this legislation passes, it will be a much less variance that you would have to request. It would be a couple hundred feet as opposed to what we have today. So, and planning would then, I believe, do a different analysis. The analysis will be different from planning. So what we're asking you to consider is perhaps either, I don't know if this has to be withdrawal or postponement.
Yeah, thank you. So if the bill passes, it looks like it would be 500 square feet per dwelling unit for minimum lot area in the R8 zoning district. So I forget the lot area, but that would be definitely a smaller variance,
Right.
if at all.
Yeah, it would be a smaller variance needed.
So do we have to wait for the bill to pass?
Yeah, it's not law now. It's
Oh, it's not law, okay.
If we
Can it
would,
be conditional? This is Bernard Height.
No.
Conditional or based on that new law?
if the law changes while an application is pending, we're required to render a final decision under the most recently passed law, right?
When it does,
If-
say
if-
it
if
comes
wha-
back.
If
say
while
we-
the application is pending, the underlying law changes, we're then required to consider the most recently passed law, right?
Yeah,
I think you have an option. Well, technically, the application is under the old code, so the new legislation doesn't impact if they're kind of grandfathered in, but they benefit from the law change, so they would argue they would refile or.
I think you would
take
have to
the
refile.
board would take notice of
under
it.
the new law to
I
take
mean,
advantage
the
of
board
it.
would the board could take notice of the law change and apply the laws.
Cleanest way, I believe, probably would be to withdraw and reapply. And listen, we don't control the city council, so, or the mayor's pen. So this is a decision you guys have to make yourself.
It sounds, well, the chair can give advice, maybe I can. Well, not really give legal advice, but it sounds like the board might not be inclined to approve today. They may be inclined to approve a smaller variance if this law I just mentioned passes.
But is it better to hold or postpone? Or is
It
better
sounds
to-
like
from our
potentially
standpoint,
what happened with the other case earlier today, that there was a continuance and maybe perhaps you'll save $100 in fees and something to keep it active and come back if the
Yes.
bill passes.
Right.
Take a continuance,
For perhaps 6 months or whatever, and then.
That would be and look, we appreciate, look. you
Listen,
guys
we-
are
we're trying to figure it out.
We're just trying to figure out how do we make it a viable building, right?
We're all trying to figure
Right.
You know, and I know we're all on the same team, so it's not, there's no contention. We're just trying to figure out kind of leveraging your brain trust, our brain trust on, footing the bill, right?
Yeah, it seems like a continuance
I have a
Probably,
question, but I
yes.
didn't want to interrupt anyone, so I'll wait till you're finished.
Yes.
I want to know, am I the first person to ever request a permit for a basement?
You will be surprised,
unit?
man. A lot of the things are unpermitted.
Yeah.
We get people who come asking for a fence, for deck, improve their deck, and they learn that the zoning code doesn't allow it, and we always hear, but my neighbor has it. And I tell them,
Right.
this is Baltimore City, unfortunately.
And I'd like to ask, is there any other ordinances? For example, there was an R8 conversion with variances at 730 East Preston Street in
If it was, that was an
2024.
ordinance, that was,
There was a conversion with variances at that address, and then there was one at 914 North Broadway. And I just wonder if there are others. It's hard to believe this is the first time anyone's ever requested a permit.
No, I
with
think
300-foot.
the issue, well, there's dozens of conversion ordinances in the R8 zoning district per about 8 to 10 a year. The distinguishing issue here is that it's already been converted. Now you're trying to take a separate unit, so you need to look at the lot area, and the degree of the variance you're seeking is higher than other places. And the planning department, for that reason, has recommended disapproval, and the board seems inclined not to, or hasn't found that you've made enough of the case to justify a larger variance.
Let me ask just one quick question, just because our big thing is we're trying to get the building going and
as soon as
going.
possible, yeah.
What's the recommendation as far as permits and getting approval to, start doing the rehabilitation of the building?
Let's talk offline.
We're still on the record. So let's try to handle this matter. I think that you guys have asked for a continuance while this pending legislation in the city council works itself out.
Right.
I think I can't say when it will happen, but it just passed second reader. So I think there are 2 or 3 more city council meetings before the year is over, so.
Should we put a time limit on the maximum?
Can I have that bill number repeated, just so I could try to follow it, please?
you got
An estimate, I don't know how it all works. How is it 2 more
Within the
meetings?
I'll discuss with you. The bill, council bill is 25-0064. This is
Thank you,
to amend the zoning code's bulk and yard requirements.
thank you.
Well, the session ends at the end of December, right? City council session, so it has to pass. No, it's 4 years.
This term goes on.
Yeah. Let's do 6 months, up to 6 months. You can, for a continuance, you can come back. If that law changes sooner, we can come back sooner, of course.
But we can't do any building until.
You can't get it until you get a permit.
Okay.
But
Yeah.
could that be 1 year, just in case that bill's not approved or a decision made timely?
We've given 12 months. How do you guys feel about 1 year?
Come back and request an extension for the other 6 months.
Yeah, we'll do 6 months, and if you need an extension, you can come back and ask for an extension. Just to make us in line with our earlier decision today.
Okay, 6 months, all right.
And look, we appreciate the partnership. We're trying to figure out how to do this in the right way.
Yeah.
Right, as we kind of maneuver through.
Yeah, so I think we're all agreeing with 6 months continuance while the pending legislation works us out in city council. Sorry, we couldn't give you a better outcome today, but I hope that you guys are able to get some relief in the
Working
city.
as a team, right?
Yeah.
All right.
Thank you guys so much today. I think that's the end. We're off the record.
We are off.